Hello the world, hello the internet, hello Jason Isaacs, hello politicos everywhere. I'm Paul, this is Paul Talks Politics, and this is where I, Paul, talk about politics. So if that's what you're interested in, you've come to the right place. Even if you haven't, even if that's not, then please do hang around, because we're going to talk about politics. We're going to talk about what this actually means. And hopefully, if you're here, it means that you've come here from my video on the US Supreme Court, which is a bit of an epic. So if you got to the end of that, well done. Thank you very much. Do like and subscribe. If you haven't watched that video, but you are interested in politics, particularly American politics, then please do go and watch it. Two reasons. First of all, it's going to make this video much more interesting and relevant. And secondly, I need the viewing hours. So that would be nice. What also would be nice would be to cue the intro so we can get on with business. And so with no further ado from me, we'll see on the other side of the intro. So yeah, see you in a minute. Bye now. So that was nice, wasn't it? Okay, so what we're going to talk about today is language, the language particularly of the Constitution, and what this does and does not mean, or more importantly, who is charged with telling us what it means and how they work that out. Essentially, what we're looking for here is the hunt for legal certainty. We need to know what the Constitution means. If we don't know what the Constitution means, then we are in big trouble. Or, as it was put memorably in Casey versus Planned Parenthood by David Souter, liberty finds no refuge in a jurisprudence of doubt. Now, what does that mean? It sounds quite complicated, but when you tease it apart, it becomes a bit more straightforward. What Casey is saying there is that if you don't know what the law means, then you can never be really sure that you are free. If the law's meaning changes constantly, then your position vis-a-vis the state is never constant, and you can't be free. You are constantly living under a state of oppression. Knowing what the law means is a fundamental bit of living in a democracy. Now, in the UK, the people who get to decide what our law means really is Parliament. If the law is not clear, the courts can give indication of what they think, but fundamentally it's for Parliament to determine exactly what the law means. If they disagree with a decision made by the court, they can legislate over the top of that and bring clarity, where previously the courts in the UK might have been going, well, look, we're not entirely sure what this means. We think it means this. And it then falls to Parliament either to agree or to say, well, no, actually what we meant was this, and then create a different law bringing clarity to that, because we need to know what the law means. We need to have legal certainty. Otherwise, we are always in a position of uncertainty. Who gets to decide what a word means at any given stage is always going to be important. It wasn't just Alice Through the Looking Glass, and if you haven't read it, you really should. It's not a kid's book. It's a fascinating bit of work. But what we are trying to do here is we're trying to establish again what it is that this here Constitution means. Now, when it comes to interpreting the Constitution, there are, to all intents and purposes, three main schools of thought. We've got strict construction, we've got originalism, and we've got LC. Now, depending upon where you're coming from, that's either going to stand for loose construction or living constitution. They're essentially the same thing. And you need to know what they are relative, I think, to the other ones in order to make sense of this entire concept. So, when you ask a Supreme Court Justice, what does the Constitution mean? They're going to approach it through one of these three windows. Either strict construction or originalism, or living constitution / loose constructionism. When it comes to strict construction, or indeed textualists, to give them their other name, so I'll just write that down for you, textualists. That is essentially the text, the whole text, and nothing but the text. That's it, nothing else. So if you want to know what the Constitution means, well, it's written down, there are words in there, and that's great. Now, in terms of certainty, that's pretty fine. and you can look at the Constitution and you can decide, well, yeah, obviously the 8th Amendment says that cruel and unusual punishment shall not be applied, or whatever it is. So there you go, that's perfectly clear. Of course, it's not. But of that, much, much more later. Originalism says, well, okay, we've got the text, but we can do better than that. What we can try to do is to infer what else might be appropriate based upon what was current or what was the prevailing political ideology at the time that the Constitution was written. So we're going to pick a fixed point. We're going to pick 1789, 1791, and that is our fixed point. If you want to know what the Constitution means, then we need to work out what it meant in 1789 to 1791, and that is what the Constitution means. So in other words, if you were wandering down the street and you bumped into a founding father because, obviously you had some sort of bizarre time machine, and you said, well, okay, what does the Constitution actually, what does cruel and unusual actually mean? They would be able to explain it to you, and you would go, okay, yeah, that makes sense. And then we take it back to our contemporary environment and we apply that standard there. So what we're saying is we've got a fixed point in time. The Constitution was written at that fixed point in time. That is what the Constitution means. So in order to know what the Constitution means, in order to know what cruel and unusual means, in order to understand what the right to bear arms means, we need to put that in the context of 1789, 1791, and then that will allow us to apply the Constitution consistently throughout the rest of time. If you've got a problem with that interpretation, if you've got a problem with what the Constitution says, because it was written in 1789 and 91, well, the answer to that is to change the Constitution, because we need to have consistency. We need to have a fixed point. And there's a certain intuitive appeal to that position, and we'll see how that position stands up when we come to look at a few examples later on. The next school is the loose/living school. Oh yeah, so by the way, the 9th Amendment is critically important in that, because what the 9th Amendment says is that, yes, we've got the Constitution and we've got the amendments, but that's not exclusive. There will be bits that we can add to that. So that's the big difference essentially between textualists and strict constructionists. That the originalists say, well, we've got that door in the Constitution, the 9th Amendment, we can open the door and it allows us to identify other rights consistent at the time. And indeed, when the Constitution changed, 13, 14, 15, the Reconstruction Amendments, we can see again more rights being added to the text of the Constitution, and expanding the range of the Constitution, and indeed expanding the range at that point of original intent. The next one up is loose construction, and they say, well, look, we've got the text and we've got the context, but that's really not appropriate. How can we take something that was ossified, that was cast in 1789, 1891, and hope to apply that to a contemporary context? We don't use physics textbooks from 1789. We certainly don't use medical textbooks from 1789. So why are we referring to a legal document from 1789? Look at Britain. We amend the Constitution all the time because we can, because we have a parliamentary system. What the American loose constructionists are saying here is that we can't just look at the Constitution as something that was written and stuck in the past. We need to try to create a sense of a living or an evolving Constitution. So yes, we've got the text. Let's see how far we can stretch it so that we can apply it in a contemporary context without everything falling apart, without either the Constitution breaking or indeed our society breaking, because society is trending against the Constitution, the Constitution is trying to pull it back. So that living or evolving Constitution idea is critical to loose construction, or indeed the living constitutional approach. So on to the 9th Amendment and why the 9th Amendment is so critical to our discussion here. The 9th Amendment says, well, you can read there. When the Founding Fathers wrote the Constitution, they got to the end of the 10th Amendment, and that was all they had time for, really, essentially. And the 9th Amendment there says, well, hang on a second, we've got to this point here, we've got to 10, The enumeration of constitution of certain rights shall not be construed to deny or disparage others retained by the people. So in other words, there might be more out there. We just haven't got around to identifying them. Now that opens the door to two things. First of all, it opens the door to more enumerated rights like 13, 14, 15 and of course 19, and that's good because we can amend the constitution, we can add those rights to our enumerated list, but at the same time it's saying that there may be others out there that are not written down here, but instead that are ICOL, which is implicit in the concept of ordered liberty, or deeply rooted in the nation's history and tradition. So they're out there, they're either implicit in the concept of ordered liberty or they're deeply rooted in the nation's history and tradition. It's just that they are not easily identified in the Constitution. Now, the reason why these things are significant is because they crop up in a couple of cases. I'm just going to flip across here. I don't know if you've come across these. Oh yeah, is an absolutely fabulous case. I'm pretty sure that Moore versus City of Cleveland was where we first came across deeply rooted in the nation's history and tradition, and that Palco versus Connecticut was where we first came across the idea of implicit in the concept of ordered liberty. Either way, these phrases are out there. OYA is a fantastic website, and you need to know that the Constitution there, what the Ninth Amendment says is that there may be other rights out there, just haven't got round to writing them in the Constitution yet. Maybe you can add them later, or maybe you can identify them through, inferring what we mean at the time. So Ninth Amendment, really, really interesting. Quite a complicated little amendment, but hopefully that makes it slightly more obvious. Now, here we see the godfather, if you will, of original intent. So we've got Griswold versus Connecticut, 1965, another Warren Court, another critical Warren Court judgment. And what they identified here was that while the Constitution, as it says, doesn't explicitly protect privacy, various other guarantees of privacy within the Bill of Rights effectively create shadows, or as they put it, penumbras or zones. So specifically, if you take the First Amendment and the Second Amendment, not the Second Amendment, but the First Amendment, the Third Amendment, the Fourth Amendment, and of course our friend there, the Ninth, then they essentially create this overlapping zone from which we may infer a right to privacy. So that Constitution does not implicitly protect privacy, but remember, the enumeration of those rights shall not deny or disparage other rights to the people. So just because privacy isn't written in the Constitution, it doesn't mean that there isn't an implicit right to privacy there. Now, this is originalist. So in that sense, the idea is that if you were walking down the street and you bumped into Madison, you said, "Oi, why didn't you include privacy?" He'd go, "Oh gosh, yeah, that's a really good idea. I wish we had the supreme." Privacy is exactly the sort of thing that our Constitution was designed to protect. We should have put that one in. We are all over. We really like the idea of privacy. You guys carry on. So that's the idea of originalism, that it's something that would be consistent not only with the text of the time, or if it's not necessarily explicit in the text, then it would have been understandable or intelligible to the Founding Fathers and to the context of the signing of the Constitution way back in the late 18th century. That's the concept of originalism, and Griswold is very much an originalist decision, that we're not stretching the Constitution. We're not trying to create something new or crazy. What we're saying is that the Founding Fathers, that this concept of privacy is entirely consistent with everything that the Founding Fathers stood for, and I just guess they just didn't get around to it. That's the general idea of originalism. Now, that's originalism. We're going to look at textualism. We're going to look at originalism. We're going to look at loose construction through the prism of two amendments. And two amendments I'm sure that you already all know and love. Now, I'm not going to read these out because they are read out beautifully in these two More Perfect episodes. Now, if you haven't discovered More Perfect yet, it is a secret weapon that will help you not only understand the Supreme Court, but also American politics generally. I've been teaching American politics pretty much since the in the independents. This series of podcasts made me think about American politics in a whole new way. I can't recommend them highly enough. They are absolutely brilliant. So with the First Amendment one, you can skip the first 6 minutes, but if you come in at about 6 minutes and 30 seconds, it's amazing. This whole thing is just fabulous. Seriously, this stuff is dynamite. You should definitely listen to it. So if we look at these amendments and we try to see what they look like from a textualist position and from a originalist position and from a loose construction position, let's see where that gets us. So we're going to start off then with textualists and strict construction. So if we look at the First Amendment says Congress shall make no law, blah, 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 freedom of thought, freedom of speech, of association, and so on and so forth. Now, that looks great on paper. The problem is, if we adopt a literal interpretation of that, it takes us into insanity. Specifically, it takes us to Schenck versus US, where somebody sold secrets to a foreign power and claimed that this was protected under their First Amendment rights. Now, that clearly makes no sense at all. You can't have ordered liberty if people are going around selling secrets to foreign powers or inciting violence or standing up in the crowded theatre and shouting fire where there is none, thereby causing panic. That just doesn't make any sense at all. So we have to accept that there is some limit to our freedom of speech. So in other words, implicit in the concept of ordered liberty is not just a list of freedoms, but also a list of duties, a duty to act responsibly, not to incite violence, not to incite a mob to storm the Capitol on the 6th of January. So there has to be some sort of limit to one's freedom of speech, because there is a difference obviously between liberty and license, between order and chaos. And if we simply prevent Congress from passing any laws that stop people inciting riots or violence or murder or espionage, then we are no longer living in the concept of in ordered liberty. We are living in chaos. So a strict construction approach to the First Amendment makes no sense, or no practical sense at all. It's even worse when we look at the Second Amendment, because the Second Amendment simply doesn't make sense. Not only is it riddled with apparently unnecessary commas, but if we look at the text, we have on one hand a well-regulated militia. Now, if you've got a regulated militia, then presumably you are imposing some sort of restrictions or limits or infringement upon what they can and cannot do. But then if you're going to say that their right to keep and bear arms shall not be infringed, well, how do you square that with a well-regulated militia? How do you square regulation with not regulated? And that's entirely before we get into the idea of, do you have to be in a militia to be able to hold arms? And, it's internally inconsistent. Or that is for my money anyway. But I just can't see how you can regulate a militia without at some stage infringing somebody's right to bear arms. It opens the door certainly to it anyway. So this phrase is internally inconsistent, but no one really cared. Hundreds of years, no one cared about the Second Amendment and the fact that it didn't make sense until the Black Panthers took up arms to protest and protect themselves against police violence, and suddenly people started paying a lot more attention to the Second Amendment at that point. And as it doesn't make any sense, then as a strict textual interpretation, it's strictly untenable. You can't look at the First Amendment and go, the Second Amendment, but that makes perfect sense. It makes no sense at all. And so without the context, the Second Amendment becomes fundamentally meaningless. The First Amendment is absurd. The Second Amendment is untenable. So this brings us to the point that strict construction is not a coherent ideology, and indeed no one really would call themselves a strict constructionist or a textualist. Clarence Thomas is about as close as we get, but he again would reject that particular label. You can't be a textualist because the Constitution, simply as it stands, great and brilliant as it is, does not make sense in certain key areas. You can look at the First Amendment, as I say, you've got to have some sort of limit to what you can say. Second Amendment doesn't make sense. Cruel and unusual, well, what is cruel and unusual? That needs some degree of context brought onto it. So yeah, textualism, strict construction doesn't make any sense at all. So let's have a look at originalism. If we look at the First Amendment through that originalist lens, and we have there Justice Holmes, that famous quote, again, from Schenck versus United States, that's the espionage case, the most stringent, well, again, you guys can read, so I'm not going to read it out to you, and you should pretty much know it anyway. So what we're saying is we're going to take that idea of freedom of speech, but we're going to put it in a concept of ordered liberty. The key word there being ordered. If you have liberty, you also have obligation. There's an obligation that you behave responsibly. There is an obligation that you respect the rule of law, and you don't go around inciting murder, violence, espionage, storming the Capitol on the 6th of January, whatever it is that absurd idea that you might have. So originalism, when we're looking at the First Amendment, makes perfect sense, because remember, we've got that concept of ordered liberty. And indeed deeply rooted in the nation's history and tradition. You can't go around inciting violence. This is part of the American culture. So originalism there makes a degree of sense. Let's flick across now and have a look at originalism through the lens of the Second Amendment. And this is where, certainly for me, the penny dropped, and well, we'll see how you guys get on. Now, this is from the Developments in American Politics, which was edited by my old politics tutor from way back. Absolutely amazing woman, Gillian Peele was. She was fantastic. Those beautiful Norham Gardens tutorials in the summer of 1890. Beautiful. My poor tutorial partner Jane had the most dreadful hay fever. Anyway, I digress. We've got to look at this. And this is a deconstruction of Heller. So Heller versus DC 2010 is one of the single most interesting laws that we've had in recent times. And in order for me to explain exactly what's going on, I just need to grab my props. Now, hang on just 1 second. I will be right back. We're back. I was trying to find my son's Nerf gun, but I don't know what's happened to it. Anyway, so what's going to happen is, for the purposes of this particular examination, this is my gun and this is my ammunition. Now, DC versus Heller was a code introduced into the United States that said, yes, you are allowed to have a gun and whatnot, but if you have a gun in the home, it needs to be kept in such a situation that it is essentially toddler proof. A toddler can't pick it up and accidentally shoot you with it. So the gun and the ammunition need to be stored separately in separate locked arrangements, so that you can't you can get it and load your gun and do, well, presumably fire it, which is what most people do with a loaded gun. But you can't have it knocking around the house just in a loaded state whereby somebody could pick it up and use it accidentally. Now, the question then becomes, does that interfere with your right, or does that represent an infringement on your right to keep and bear arms? Now, Scalia here, 64-page opinion for the Conservative majority, a magnum opus of original intent. This is fantastic. Deconstructing in exhaustive detail each word of the amendment, declaring the framers intended to protect the personal right to firearms. Again, if you're interested in doing a deeper dive into this, there's an amazing Malcolm Gladwell revisionist history podcast series on guns at the minute in the United States, about 6 or 7 episodes. It's really, really good. So Scalia looks into the context of this decision, in the process reflecting on the Glorious Revolution in England, King George's efforts to disarm the colonists, and William Blackstone. So that's what Scalia does. He does all of that. 64 pages. I mean, what an effort. And he said, this is what the Founding Fathers wanted. If we look at the text and we look at the context, then quite clearly what the Founding Fathers were trying to protect here was the personal right to own firearms, to possess firearms. and this legislation or this code is inconsistent with that and is therefore unconstitutional. Not so fast, however, say Justice Breyer and Justice Stevens. So they write separate dissents combining another 100 pages that also excavated 17th and 18th century documents, but they, of course, came to a different conclusion. So why does this matter so much? Why it matters so much is that here we've got Scalia for the Conservatives looking into this and saying that I've done all of this research on the Constitution and the context, and you know what? Everyone here, what the Founding Fathers wanted was a personal right to firearms. Breyer and Stevens do inevitably their own research, and that's another 100 pages of study, and they come to a different conclusion about the Founding Fathers' views. Now, what does this tell us? This tells us that originalism is not legal certainty. Remember, that's what we're looking for here. We're on the hunt for legal certainty. And the whole purpose of originalism is that it is supposed to lead us to that land of legal certainty where we know for certain what the words mean, because remember, liberty finds no refuge in the jurisprudence of doubt. So what they're saying here is, if remember, the idea behind originalism is if we take the words and the context, it will give us their meaning. Well, this is what Scalia's come up with. This is what Breyer and Stevens have come up with. They've both done amazing levels of research, but they have come to fundamentally different conclusions. So what this tells us is that originalism is not going to give us that legal certainty, which means that it is essentially just another word for opinion. And if we're talking opinion, we're talking politics. And if we're talking politics, then we're not talking law. We are talking subjective decision making, for which you should be held democratically accountable. So originalism, while it appears to give us that degree of legal certainty, certainly, well, if we're looking here at the freedom of speech, it looks reasonable. When we come over here, we find that actually it doesn't give us the certainty that we were looking for, and indeed we find that originalism is just really tarted up opinion. We then come to loose construction. Again, all the while here, we're looking for that legal certainty. We're looking for a fixed point so we can say this is what the Constitution means. Loose construction says, well, we can take a pragmatic approach to this. You know, the Constitution is whatever we need it to mean in any particular context, as long as we can stretch it long enough. But the problem with that, of course, is that the people doing the stretching are not democratically accountable. And if you're going to be shaping public policy, and if you are the last arbiter of public policy, then you should really be held democratically accountable. So while it is pragmatic and while it has that pragmatic appeal, it comes with it a lack of democratic accountability that is worrisome, particularly for the Conservatives in the United States. And you know, any reasonable person is going to look at it and say, well, that's problematic. That really is just opinion. If you're stretching the Constitution as far as you possibly can, then that's moving further and further away from legal certainty and more into politics, and that is intensely problematic. We get exactly the same argument when we look at the Second Amendment. It works, but we're moving further and further away from law and more into politics. And if you're in politics, then you should be democratically accountable. So what we find here is there are problems with both sides. Opinion, the originalism is really just opinion, which is politics, and loose construction is no less opinion, and so no less politics. So both of these schools draw the Supreme Court out of law and into politics. I suppose if you're going to try to say one was better than the other, well, at least loose construction isn't pretending to be anything other than what it is, which is an attempt to stretch the Constitution to fit contemporary times and morals. So where does this take us? This leads us to the general observation. There is no obviously right approach to the Constitution. The Constitution doesn't come with instructions. And we're stuck with the text that was written in 1789 and amended 27 times thereafter. The problem with that amendment process is the amendment process is based upon a state in 1789 where you had 13 homogenous states. That was white, slave-owning, Protestant, mercantile states, where you would have had a chance of getting an amended constitution. So if you're looking at the constitution and it's not working, then the idea was you would change the constitution. Now, again, that's the strict construction point of view, that the strict constructionist says, well, you've got a constitution, you've got a problem with the constitution, you've got to amend the constitution. And indeed that's the same position as the originalist. But we know that the constitution now is too hard to amend. The threshold for the constitutional amendment process is 2/3 of both houses and 3/4 of the states. So good luck getting that on any day. On the other hand, we can look at the appointment process, and I criticised the appointment process previously, but there aren't that many wingnuts who get on it. It is democratic once removed, and so when we look at the Supreme Court, there aren't too many people on there who shouldn't be on there. And SCOTUS does tend to track wider sociological trends. If the president is being elected and Congress, of course, the Senate is elected, then in theory, at least, the Supreme Court should track those demographic trends. However, we know that both Congress, both the Senate, and the presidential electoral systems are flawed, and they vastly overstate the influence of the less populated states, which effectively distorts the entire outcome. But that's a story for another day. So, strict construction makes the strongest claim to legal certainty, and it limits the role of the judiciary the most spectacularly, but it's unworkable as an outcome. The Constitution simply doesn't work if you adopt a strictly textualist or strict construction point of view. Originalism makes a claim to a middle ground. It makes a claim to legal objectivity. It claims that we can infer what the original intent was, and that gives us a fixed point or legal certainty, allowing us to go further. You got a problem with that? Change the Constitution. But as I think we've explored, that claim to legal certainty is dubious/spurious, and the constitutional process nowadays is not, unfortunately, a practical solution. Loose construction, we have a switch from dogmatic to pragmatic. That gives us flexibility and easier answers. If we argue that the appointment process tends to weed out the entirely unreasonable characters, then surely this would be a reasonable route down which to go. The problem, however, then becomes that judges are the architects of the civil state. The judges have that final say over what the civil state actually looks like, and they are undemocratic and they are unaccountable. And I suppose the other point that I would make at that point, is that loose rights are easy rights to get rid of, as we've seen with Roe v. Wade, where suddenly a change in the court means a change in public policy, and these people are unaccountable and unelected. In fact, as we said earlier, the Supreme Court now is dominated by appointments from the Republicans, and in many instances Republican presidents who were not elected by a majority of the population and who were ratified by a Senate that spoke for 43% of the population. So there are problems all the way through here, and certainly no easy answers. Scalia, in a matter of interpretation, said this, and he basically lays it out, that courts have no intelligible, generally accepted and consistently applied theory of statutory interpretation. But he then delivers an idea that judges should embrace a position that we might call intensely conservative, that you want to remain consistent. We don't want to be unnecessarily active and strike down legislation or reverse precedent recklessly or carelessly. So he then called strict construction a degraded form of textualism that brings the whole philosophy into dispute, and that loose construction was without democratic authority. So some interesting points that he makes there. And one final point before I move, and we were talking earlier about the peculiar philosophy of Justice Clarence Thomas. There he is out there in Gonzalez versus Reich. It's arguable that Clarence probably stays closer to the text than anybody. And if you remember, Gonzalez versus Reich was to do with the medical, the decriminalization of the decriminalization of medical marijuana in California. And here, I think Clarence Thomas is looking at the original intent of the framers versus his innate conservatism, and he came down on originalism, which I quite admire him for. In the early days of the Republic, it would have been unthinkable that Congress would prohibit the local cultivation, possession and consumption of marijuana, even as he seeks to stamp down on liberty and rights elsewhere. Right, okay, that is more than enough from me on the Supreme Court. I do hope that's helped. There's lots still to talk about, particularly that whole idea of judges as the architects of the civil state. All legislation, all decisions of courts are effectively provisional pending rubber stamping by the Supreme Court, and that just means that the Supreme Court is in charge. It is the scotocracy, I think is the word that I've coined, that works in America, and I think that's probably something that I will explore in my next video. But until then, like and subscribe. Questions below the line, any queries, comments, drop them in, and clarifications, I welcome those as well. And I will see you in the next video. Thanks for your attention, take care, and get those questions to me. All the very best now. Bye.